Finally, I'd like to say a word about conscientious objection. The BCCLA stands for freedom of conscience and has fought for it regularly in the courts. As we know, physicians are not required to provide physician-assisted death. The solution we would propose is that physicians should have to notify some third-party body, whether it's the hospital or the health authority, of their refusal. Not provide an effective referral, but simply notify with the permission of a patient that they do not want to carry out this service. In that way, there can be a transfer of care for the patient.
You had suggested a system when we were talking about conscience rights. You were suggesting a system where a physician would be able to tell a third party that they had objected.
Yes.
And simply that they had objected. And I was just wondering if you could maybe flesh that out a little bit more as to how that system would look. So who would be this third party? What would that look like?
Well, this, of course, we think is actually a matter for the provinces because it's about regulating access. Quebec provides an excellent example where, and essentially we endorse the model that Quebec uses. In Quebec, it's a local health authority. It would be up to provinces to figure out what is the appropriate body to notify. The key is that, so perhaps it's the hospital, perhaps it's, in British Columbia we have regional health authorities, or another body that could be designated. But the key is that then that body would be under an obligation to, as quickly as possible, contact the patient having given consent for that information to be transmitted to them. And that body would then be in charge of setting that patient up with someone who could provide the service. It gets the doctor out of having to make an active referral. They simply have to tell someone that they're refusing. We don't think that that's too much to ask. The right to conscientious, or rather the interest in conscientious objection is a carefully qualified interest. It isn't absolute. And we think that forcing a physician to engage in an active referral would be going too far, but that this is an accommodation that would serve everyone.
Thank you. And you did mention there is that privacy issue about the patient having to give consent for that information to go to the third party. Do you foresee any stumbling blocks in there? Is there anything that we should be watching for in that part of the procedure to ensure that there's proper information for the patient that's available?
Well, we think it would be a matter simply of asking the patient. Presumably the patient is in a conversation with the doctor who is refusing. A doctor who, under the norms of informed consent, would have had to provide information about the treatment. We would not excuse doctors from that obligation. And that it would be simply a matter of saying to the patient, may I indicate my refusal to this body? And if they say yes, then the doctor can do that. If they say no, then the doctor doesn't have the permission to make that indication.
Suicide and voluntary euthanasia are both covered by the Carter decision. Assisted suicide would be an example of where a patient is prescribed medication, life-ending medication, by a doctor, and that patient self-administers the medication. In some situations, an individual will be incapable of doing that, or they may simply prefer to have the assistance of a doctor, and that's why in certain contexts voluntary euthanasia will be the preference for patients and frankly for doctors as well. The term used to describe both of those types of end-of-life care is physician-assisted dying. That was the term that was explicitly defined by the BC Supreme Court, and the Supreme Court of Canada, in striking down both Sections 14 and Sections 241B, made it clear that it's referring to both of those practices. I should add that at no point did the government in the Carter case take the position that a constitutional violation applies to one form of end-of-life care and not to another. And that's why I say it's simply inconceivable that the court's decision could be taken to mean anything other than the criminal prohibition against physician-assisted dying, as I have defined it, is unconstitutional.